afternoon. Please be seated. Good afternoon, everyone. This is Judge Stickles. We're on the record in the case of Lannett Company, case number 23-10559. Good afternoon, Mr. Cohen.
Good afternoon, Your Honor. Howard Cohen, Fox Rothschild, counsel for the debtors. Your Honor, we'll be working today off the second amended agenda. It's at docket number 237. Your Honor, before we turn to the only item going forward today, which is confirmation of our prepackaged plan, I just want to thank the court and its staff for all the time and effort it's put into this case and getting us here today on a largely consensual basis. So thank you, Your Honor. With Your Honor's permission, I'm going to yield the podium to my co-counsel, Ms. Jones of Kirkland & Ellis, who's going to walk through confirmation.
All right, thank you. Ms. Jones?
Good afternoon, Your Honor. Elizabeth Jones of Kirkland & Ellis on behalf of the debtors. I'm joined today in the courtroom with my colleague, Mr. Greenblatt, and Mr. Marks, as well as a number of associates without whom we wouldn't be here today. Thank you, Your Honor, very much again, as Mr. Cohen said, for your and your chamber's help in getting us here. We're very pleased to be here seeking approval of the debtor's disclosure statement and confirmation of the plan. When we were last here before you a week ago, we had announced the terms of a global settlement in principle, and we are now here basically to implement those through the plan and revise disclosure statement. Your Honor, the debtors, the committee, the crossover group, and the U.S. trustee have been working very hard in the last week to implement that through the amended plan that we filed on Monday night at docket number 220. In addition, Your Honor, certain of the provisions have been implemented in the revised proposed confirmation order that was filed today at docket number 237. Apologies for the last minute filing on that, but we can walk through some of those changes at the end if helpful. And we
237?
Yes, we have additional copies if you would like us.
Yes, that'd be great.
Or sorry, you're on 236.
Okay, I have that. Okay, I have that. I just thought maybe it was filed again, and I was like, well, I don't have. No, I've seen that. Thank you.
Okay, no problem. Your Honor, the amended plan provides a value maximizing path forward for the debtors and the majority of its stakeholders. Through the plan, the debtors will de-lever their balance sheet by approximately $597 million and will have access to post-petition financing through a new revolving credit facility. Moreover, more importantly, it leaves the holders of general unsecured claims completely unimpaired and now provides a meaningful recovery to holders of convertible notes claims. Your Honor, as a result of the debtors' pre-petition efforts and the good faith negotiations during these Chapter 11 cases, the debtors now stand here ready to confirm their plan and get approval of their disclosure statement on their originally proposed confirmation timeline. The debtors' plan, as amended, is supported by the majority of their stakeholders. Importantly, no party that was entitled to vote on the plan voted to reject, and it's nearly 100% did vote and consensual, about 100% voting in the second liens and close to 95 in the first. In addition, Your Honor, the global settlement resolves the informal comments and informal objection from the indenture trustee for the convertible notes. Your Honor, now we have about one remaining issue for confirmation, which is the opt-out and the third-party releases, both of which we fully briefed in our memorandum filed at docket number 203. So, Your Honor, with that, unless you have any other questions or you'd like to hear from anyone else, I propose to move forward with confirmation.
You may move forward. Thank you.
As an initial matter, Your Honor, thank you very much for entering in all of our orders on CNO. We very much appreciate that in advance of today. So, Your Honor, with respect to both approval of the disclosure statement and confirmation of the plan, if it's acceptable to you, we'd like to start by moving the evidence into the record before putting on our case in chief.
Certainly.
Thank you. Your Honor, on June 6th, we filed our witness and exhibit list at docket number 225. We did recently file an amended there at docket number 238. Do you have a copy of that, or would you like us to provide?
I don't, but I saw it.
Okay.
And I reviewed the documents that you filed today.
Your Honor, in the witness and exhibit list, we've identified 5 witnesses in support of our case in chief. At this time, Your Honor, we do not intend to offer any live testimony, nor are we presently aware of any objections to the declarations or of an intent by any party to cross-examine. They are, however, all here in person or remotely, and are able to address any questions from the court or other parties.
Okay.
So with that, Your Honor, we propose dispensing of live testimony, moving the declarations into the record one at a time, and tendering the witnesses for redirect for any cross-examination or questions from the court.
Okay.
Your Honor, with respect to the declarants that are here in person, would you like them to stand or otherwise identify themselves?
If they could stand, that would be great.
Okay.
Thank you.
So, Your Honor, starting at the top of the witness and exhibit list, our first witness is Mr. Paul Deutsch of Omni Agent Solutions, who is here in the courtroom today.
Good afternoon, Mr. Deutsch. Does anyone object to the admission into evidence of the declaration of Paul Deutsch at docket number 215 or the supplemental declaration at docket 234? Okay, hearing none, those declarations are admitted. Does anyone expect to cross-examine Mr. Deutsch regarding the content of his declaration or supplemental declaration? Okay, hearing no one, those declarations are admitted without contradiction.
Thank you, Your Honor. The next witness on our witness list is Mr. Samuel Israel, the Chief Legal Officer and General Counsel of Lannett Company, Inc. He is also here today in the courtroom with us.
Good afternoon, Mr. Israel. Does anyone object to the admission into evidence of the Israel declaration at docket number 215? Hearing none, the declaration is admitted. Is there anyone in the court today or on Zoom who wishes to cross-examine Mr. Israel regarding the content of his declaration? Hearing none, the declaration is admitted without contradiction.
Thank you, Your Honor. Apologies, just for the record, his declaration was docket number 218, and I just want to make sure that's accurately reflected.
Oh, thank you. That's the number I had written down. Sorry for whatever number I said.
Perfect. Thank you, Your Honor. The next witness on our list is Mr. Ronan Bojwell, the Senior Managing Director of Guggenheim Securities, who is also here in the courtroom with us today.
Good afternoon, Mr. Bojwell. Does anyone object to the admission into evidence of Mr. Bojwell's declaration at docket 216?
Correct.
Hearing none, the declaration is admitted. Does anyone wish to cross-examine the declarant regarding the content of his declaration? Okay, I hear none. The declaration is admitted uncontroverted.
Thank you, Your Honor. The next witness on our list is Mr. Puneet Mehta, who is also a Senior Managing Director at Guggenheim Securities, who is also here with us today in the courtroom.
Good afternoon, sir. Does anyone object to admission of the Mehta declaration at docket number 217? I hear none. The declaration is admitted. Is there anyone who wishes to cross-examine Mr. Mehta regarding the content of his declaration? Okay, the declaration is admitted without contradiction.
Thank you, Your Honor. The last witness that we have on our list is Mr. Timothy Draglin, Senior Managing Director of FTI, who is available remotely today. His camera is turned on and he's
Good afternoon, Mr. Draglin. Is there anyone
Good afternoon.
Is there anyone who wishes, or is there anyone who objects to the admission of Mr. Draglin's declaration at docket number 223?
correct.
I hear none. The declaration is admitted. Does anyone wish to cross-examine Mr. Draglin this afternoon regarding the content of his declaration? Okay, the declaration is admitted without contradiction.
Thank you, Your Honor. That's it with respect to our declarations. We identified a number of exhibits as well, but are not seeking to move those into the record right now. So if Your Honor has any questions with respect to evidence, we'll go ahead and move forward with the disclosure statement portion of the hearing.
You may move forward. Thank you.
Thank you, Your Honor. Your Honor, the debtors filed their disclosure statement at docket number 17 and commenced solicitation of both the plan as described in the disclosure statement on May 2, shortly before filing these cases. Your Honor, as further explained in our brief, both the disclosure statement complies both with sections 1125 and 1126 of the Bankruptcy Code and was not subject to compliance with the securities laws and so was required to provide adequate information. We won't go into further detail here, but just to note for the record and as explained in our brief, the disclosure statement we believe satisfies the adequate information requirement as it provided a summary of the debtor's pre-petition business activities, a summary of the events leading up to these cases, explained the claims and treatments anticipated thereunder, as well as certain risk factors and disclosures. So we haven't received no objections or formal or informal comments with respect to the disclosure statement. So unless Your Honor has any other questions, we'll move forward with the plan and then seek approval of the disclosure statement in connection with the confirmation order.
That's acceptable.
Thank you, Your Honor. Your Honor, now with respect to the plan, we again appreciate you entering the order allowing us to exceed the page limits. We fully briefed the issues in there and will mostly rely on our papers. Again, that was filed at docket number 203, but we want to highlight a few of the key points for the record here before moving on to the open items left for confirmation. So, Your Honor, the debtors submit that the plan satisfies the requirements of confirmation and was proposed in good faith and does not discriminate unfairly and can otherwise satisfy the requirements of Section 1129 of the Bankruptcy Code. Your Honor, pursuant to the plan as amended, Holders of first lien secured notes claims will receive a meaningful 91% recovery in the form of both take-back exit facility paper and new common equity. Your Honor, with respect to the second lien term loan claims, they will receive a 5% recovery in the form also of the take-back exit facility, new common equity, and warrants. Your Honor, perhaps most importantly here to the debtors as they move forward and reorganize is that it has now left holders of general unsecured claims completely unimpaired, as also further reflected in our amended plan to make that very clear. Lastly, Your Honor, with respect to the convertible notes claims, as a result of the global settlement, they will also be receiving a meaningful recovery and will receive about 1.25% of the new warrants issued under the plan. With respect to the other classes, Your Honor, those junior to Class 6, the convertible notes claims, are not receiving a recovery, and so we believe the plan complies with the requirements of all holders of the claim and follows the priority scheme. Your Honor, as previously noted, the plan solicited for Classes 3 and 4, starting prior to the petition date and ending on May 16. Your Honor, we've received no objections to the plan or rejections or other comments from those voting parties, and we had unanimous consent with all holders of the second lien term loan claims voting yes and nearly all of the first liens. Lastly, Your Honor, as we noted in our brief, and we'll rest on our papers there, we believe it satisfies 1129. We received 4 formal objections to the plan and certain informal. 2 of those formal objections at docket number 172 and 174, as demonstrated in Exhibit A to the brief, we've resolved through language in the confirmation order or otherwise through the plan. With respect to the remaining 2, both from the U.S. trustee at docket number 200 and the SEC at docket number 175, we've partially resolved both of those. With respect to the U.S. trustee, we believe that we're fully resolved except for with respect to the third-party releases. And with the SEC, it's the same with respect to the jurisdiction of approving those releases. In addition, Your Honor, there was one statement at docket number 184, which reflected the opt-out by a group class, which was resolved through the stipulation that you entered at docket number 189. So, Your Honor, that brings us to the one contested point of confirmation. Again, we briefed that fully and we'll rely mostly on the papers, but we thought that it was important to note that both we believe in this circumstance and as courts in this jurisdiction have held that the opt-out is a consensual form of release, provided parties with adequate notice, and that, again, as held in other courts, for example, in Emerge, that the ability for equity holders as well as creditors to review their mail and make that determination is sufficient to deem a release consensual. We did receive certain opt-outs from existing interest holders that further demonstrates, and not only did we serve the nominees, but if we knew the individual security interest and had that information, we also served them with notice of opt-out. So with respect to that, we do think it's consensual, but also understand the need to demonstrate that they are fair, equitable, and reasonable. And as we set forth in our papers, we do believe we've met that standard here. This is a company that is moving from public to private and has worked very hard, and many parties have made a lot of sacrifices to equitize their secured debt so that they can restart fully fresh. We do think that providing those releases so that directors and officers are no longer tied up in go-forward litigation is necessary and appropriate here. With respect to the convertible notes, Your Honor, we do believe now they are also receiving a meaningful recovery, and that there were less than 10 holders of convertible notes prior to the prior to the petition date, and 1 did return an opt-out. So we do think, especially with respect to the convertible notes claimants, we've satisfied the requirement through the opt-out. We do as well believe with respect to existing equity interest and 510B claim holders that it is important to keep these releases in place, but as we further said in our papers, we understand there are differing opinions here, and unless Your Honor has any specific questions, we'll rest there on those papers.
All right, thank you. I'll hear from the SEC and U.S. trustee. Good afternoon, Mr. Cudia.
Good afternoon, Your Honor. Joseph Cudia for the United States Trustee. First off, I want to thank Debtors Counsel, both the team at Kirkland and at Fox Rothschild for their hard work on this. As a result, we're down to 1 issue from all the issues in our objection. The only remaining issue concerns third-party releases where the debtors have proposed an opt-out procedure for consent to give those releases. for those classes that are deemed to reject and getting nothing under the plan, especially the existing interest holders. Now, the plan defines releasing parties, in pertinent part, as all holders of claims or interests that are deemed to reject the plan and do not affirmatively opt out. As I'm sure you're aware, it's the position of the United States trustee that the only form of affirmative consent is an opt-in procedure. But of course, knowing your Honor's past rulings on that subject, all we are objecting to here is the opt-out procedure as applied to public equity holders who are deemed to reject and are getting nothing under the plan. We are asking you that in order to find for such releases to be consensual on these facts and circumstances, claimants of a non-voting class getting nothing must affirmatively opt in to grant those releases. If it's non-consensual, pursuant to the holding in Continental, the releases need to be necessary to the organization and fair. There's no reason for shareholders to appear here as they are far out of the money and they've known it. To impose a duty on the shareholders to send in an opt-out form is patently unfair, especially when no consideration flows to them. Not only have they lost their investment, but in order to prevent releases from being extracted from them, they need to respond to a notice they may not understand, perhaps seek counsel at their expense. Now, according to the voting results, only 10 existing interest holders opted out of granting the third-party releases. Now, again, the Lannett petition states that there's probably less than 500 existing equity holders, but that nobody really knows. Even if it's only half that amount, only 4% of the equity holders opted out of the releases. And we believe it speaks more to the notice, lack of notice, or lack of motivation than the generosity of the overwhelming majority of equity holders. In order for the shareholders to get that notice, they have to rely on their broker sending them the notice to the beneficial holders. Those beneficial holders then have to return the opt-out forms to the brokers, and then hope the broker submits them in time. There's just no way to assure that each beneficial holder received notice, especially on the tight timeline of these cases. It just doesn't make sense that a vast majority of shareholders would give a gift to the debtors after losing their investment in exchange for nothing. Of course, it is the position of the debtors that the opt-out process used in this case results in the third-party releases being consensual, therefore permissible without meeting the standard in Continental for non-consensual releases. One of the cases that the debtors point to in their brief is the Mallinckrodt case that was heard by Judge Dorsey in support of the premise that equity holders who are getting nothing can be bound by an opt-out. But however, in the recently decided Tricida case, Judge Dorsey ruled from the bench that the opt-out procedure as to the out-of-the-money shareholders needed to meet the Continental standards. He distinguished the holding in Mallinckrodt as necessary in the context of a mass tort case. And then in citing Indianapolis Downs and Spansion, he stated, I quote, "I am of the view that a non-voting class is being asked to opt out of the releases. The debtors must show that the releases are fair, equitable, necessary, and integral to the proposed plan." Mr. Israel's declaration in support of the plan, starting at paragraph 60, talks about the third-party releases and the parties being released. Many of those releasees are just persons doing their jobs for which they're compensated at the expense of the shareholders. And a release of many of them would fail to meet most of the master mortgage factors. And that is for those actually involved in the case. The broad definition of related parties sweeps in an untold number of persons, many of whom probably have no involvement or even no knowledge of this case. They certainly could not have requested these releases. Paragraph 64 of Mr. Israel's declaration asserts that parties bound by the releases are receiving sufficient consideration. Any consideration provided by the released parties is certainly not being received by the equity holders. Also in paragraph 64 is a conclusory statement that the declarant's understanding that key stakeholders would not have been willing to fund and support the restructuring. That statement is just not sufficient to provide evidence that the releases were necessary.
Doesn't he also go
yes.
on to say that the releases were integral to the process here?
Yes, that is his assertion, yes. In paragraph 65, he talks about the claim necessity of the third-party releases with respect to the holders of existing interests, and how the restructured company, current managers, officers, and employees may be subject to litigation risks. To the extent that that might happen, some of that is covered by insurance. Further, Continental addresses that very topic, and I'll again quote, "Even if the D&O defendant's obligations, culminating from the plaintiff's class actions, were indemnifiable, the fact that the reorganized Continental Airlines might face an indemnity claim sometime in the future in some unspecified amount does not make the release and permanent injunction of plaintiff's claims necessary to ensure the success of Continental debtors' reorganization." In summation, Your Honor, the shareholders trusted the company with their money. Now it's gone. But that was the risk they took when they bought the shares. It should not be compounded by losing any legal rights they may have for redress from non-debtors without positively and affirmatively consenting to same. It's the debtor's burden to demonstrate that under the facts and circumstances of this case, the third-party releases are consensual. It's the position of the UST they haven't done that. Absent that, they need to show fairness, necessity of the organization, and specific factual findings to support those conclusions. That's all I have, Your Honor.
So, Mr. Cudia,
Yes.
I want to ask you a couple of questions.
Sure.
So, you would have this court draw a line and say that there can never be a consensual release when there's a class who is either non-voting or isn't receiving something under a plan.
Where we would have you look, Your Honor, is look at the facts and circumstances of each case, just as Judge Dorsey did in Tricida. He recognized that, for instance, in Mallinckrodt, there was an overwhelming need for finality and for a settlement of a mass tort case, and under those circumstances, he approved it. Whereas in Tricida, where those same circumstances were not present, he did not.
In Tricida, didn't Judge Dorsey make some judgments about, for example, people losing interest in a case?
Yes, and I believe that would also be the case here, Your Honor. Again,
And why do you believe that?
because they've already found out they're receiving nothing. They have no motivation to any more look at what's going on.
Well, in this case, and it's a pre-pack, right? Yes. The time period we're talking about is rather short, given the nature of the case. So they learned of the case filing at the same time they received notice of this combined hearing and an opt-out form. Is that not right?
I believe you're correct, Your Honor.
So to suggest that there's fatigue from getting a lot of paper or that you might lose interest because you're out of the money seems hard. It's a hard-pressed argument to me, given the facts of this particular case.
Well, I think it goes as much to motivation as anything else. Once they find out they're not getting anything, there's really no reason for them to look further. And that's kind of how I would look at it.
Well, the particular notice in this case, there were numerous comments regarding opt-out. You would agree with me?
Yes.
And wasn't there a text box on the very front of the notice?
Yes, we did not have any issue with the form of the releases.
Okay. Let me ask you a little bit about the U.S. trustee's argument suggesting that there is deficient service utilizing the service of a nominee.
I don't know that I would classify it, Your Honor, as deficient. I believe it's been found in many courts to be actually sufficient.
Well, I mean, isn't that the way that public companies communicate with shareholders?
Yes.
So, what is your argument that that's not a sound system for providing notice?
I believe it may be the best that's available, but it's also not very good.
So would you agree with me, though, that if somebody didn't get notice, they could certainly come to this court and raise issue with notice, and that absent notice, a party is not giving a release?
Certainly, Your Honor.
All right, thank you, Mr. Cudia.
Thank you, Your Honor.
Good afternoon, Your Honor. Patricia Schweig for the Securities and Exchange Commission.
Good afternoon.
Your Honor, I'm here on the limited objection with respect to the non-debtor third-party releases, specifically with respect to shareholders. And I'll try not to repeat
Okay.
what the U.S. Trustee's Office said, but it's really the same position. The cases are the same. Your Honor, we're here because these provisions concern the SEC when they impact public investors. And many times these shareholders are not in a position to advocate and come into these bankruptcy cases themselves. So we're here really just to make sure that they are fairly treated. Many times these releases enable the non-debtors to benefit from the debtor's bankruptcy case by obtaining their own release, a release that they wouldn't have been entitled to if they had filed an individual bankruptcy case, including for past misconduct, violations of the federal securities laws. These claims would not have been discharged in those individual cases. So here, the releases are not fair to the public shareholders and the subordinated claimants because they're not consensual. Our view is that they're not consensual, and rather the debtors are seeking to buy these shareholders and subordinated claimants who are not voting. They're deemed to reject. They're getting no consideration. So they're seeking to buy them if they don't opt out, and that's really the issue here. And therefore, they should have to satisfy the test for non-consensual releases and show that the release is fair and equitable and necessary and integral to the plan. Your Honor, as you know, in this circuit, the releases must either be consensual or satisfy the standard approved as non-consensual under Continental. And here, the releases as to the shareholders and those subordinated claimants are not consensual. The shareholders are not voting on the plan. They're not getting anything, and they're deemed to reject. But they must opt out or they are bound. Silence should not be their deemed consent. As the court in Emerge Energy said, the failure of a creditor or an equity holder to return a ballot or an opt-out form does not manifest their intent to provide the release, to consent to the release, but rather carelessness, inattentiveness, or a mistake are three reasonable explanations. Your Honor, the shareholders are not receiving a distribution. They're not able to vote. There's no incentive for them to thoroughly read and consider and return these opt-out forms. And particularly, it's onerous to place this opt-out requirement on public investors, many of whom do rely on these intermediaries to deliver the appropriate forms and instructions, and often, as the case was here, in a short amount of time. Your Honor, if the releases are not consensual, then the debtor must show that the releases satisfy the standards in Continental for non-consensual releases. As the Third Circuit has stated, the court must conclude the release is fair to the releasing party, particularly whether the release is given in exchange for fair consideration, necessary to the reorganization, and the court must make those specific findings to support the conclusion. Here, with respect to the public shareholders, the releases are unfair and lack any consideration. The releases as to the shareholder are not necessary or integral to the plan. As the U.S. Trustee had stated, the fact that these releases are needed to
to bar shareholders from bringing claims or causes of action against current managers, officers, and employees, so they won't be distracted, or to avoid litigation costs, do not support the releases as integral and necessary, but rather are the cost of doing business. Your Honor, just briefly on...
Can I stop you before
Sure,
you make
please.
your next point? So, in your argument, if an opt-out was for a general unsecured creditor who was receiving 1% under the plan, that would be a consensual release, but a shareholder who is not getting anything under the plan, the opt-out would not be a consensual release?
Your Honor, I wouldn't necessarily say that. I think that the 1% is very similar. However, particularly in this case, there is committee counsel who came in and negotiated it, and that is why we need to have these fiduciaries come in and represent these stakeholders who might not have gotten anything if there wasn't a committee appointed. So
if there had been an equity committee, your position would be different?
I don't know if the position would be different. I think looking at the facts of each case, in this particular situation, the shareholders are deemed to reject. They're not voting. They shouldn't be bound by these releases. That's consistent with several cases in this district. We've only more recently seen the debtors trying to bind those who are out of the money, deemed to reject, not voting, to be bound by these releases. I do think when you look at what stakeholders are getting, they may too not want, maybe fatigued, may not want to look at the papers for their 1%. But in certain cases, I do think we can look at, we could consider that they have had active counsel. Maybe counsel has put a letter in with a disclosure statement and plan that explains things in more detail. However, we raise this issue to all public investors, with respect to all public investors, not just with out-of-the-money shareholders, but here, this is a limited objection with respect to the opt-out as to the public investors in this particular case.
So your position would be that the court has to approach every case differently depending on the facts?
Yes, to look at the facts of the case. But Your Honor, I do think that over the course of time, these releases have been broadened and to include more stakeholders. And I do think it's important to look at some of the prior cases where the courts have perhaps allowed them, but not as to those stakeholders who are out of the money and deemed to reject and not voting. Your Honor, just really briefly on jurisdiction. If the court decides to approve the non-debtor third-party releases, the court has to determine if the court has the constitutional authority to approve a plan that contains these broad releases. Releases that would release, say, state law claims and other non-bankruptcy claims, non-core matters. So under Millennium, Your Honor would need to find that the releases are integral to the debtor's restructuring of the creditor-debtor relationship, and the court needs to make that finding. And there was just, similar in the recent case of Purdue, the circuit held and the Second Circuit held that the bankruptcy court does not have the constitutional authority to enter final orders on non-core matters, but the bankruptcy court can resolve claims that impact the res of the estate. Your Honor, do you have any other questions?
I don't think so. Thank you.
Thank you, Your Honor.
I'll hear from the debtors.
Thank you, Your Honor. We have nothing particular to point back other than to note, as you did, that with respect to the very first notice that the equity holders received in this case, it was very clear what their recovery prospects were and what needed to be done to opt out of the release. We've engaged with all parties that have reached out to us, and again, point back to the stipulation as well at docket number 189 to demonstrate any shareholders that had a question or were intending to opt out, we also were more than happy to engage and note that in the opt-out forms as well.
Was there any prior notice to shareholders before the notice, I think it was a notice of commencement, notice of combined hearing, with the opt-out attached, non-voting status? It was all one, well, there were two different notices, but that was all one package, correct?
Yes, that's correct, Your Honor. There was no formal notice given to equity holders through the bank, or connected to the bankruptcy. There was, we filed as a public company the RSA and the intent to file as well publicly and made those announcements, but no, there was not a specific notice sent out.
Okay, thank you. Does anyone else wish to be heard with respect to releases? Okay, are there any other issues? Or is that, sorry, I should have got you before you sat down.
With respect to confirmation, no, Your Honor, that was the only open point. I will note there is item number 12 on the agenda. There was a fee ceiling request with respect to the plan supplement.
And I didn't enter that?
You did enter the request to shorten notice, but I believe we reserved, the U.S. trustee didn't have any issues, but we left it open so if anyone had a concern today. But we provided both the unsealed letter to the committee and the U.S. trustee. We've received no formal or informal comments or questions, so we're just seeking entry of that order.
Okay, well, let me ask you real quick. Did anybody want to be heard with respect to that motion? Okay, I'll make sure, I did review it, and I will make sure that it's entered.
Okay, thank you.
Okay.
Otherwise, nothing else for confirmation of the agenda from the debtors.
Okay, so let me say that based on my review of the record in these cases, the evidence and the argument presented in support of confirmation, I find the plan satisfies the requirements of the bankruptcy code and will confirm the plan. In terms of meeting the requirements for approval of the disclosure statement and confirmation of the first amended plan, the debtors have admitted into evidence the Bogue-Mel Declaration, the Meta Declaration, the Israel Declaration, the Draglin Declaration, and the Declaration and Supplemental Declaration of Paul Deutsch. The declarations are uncontroverted and support approval of confirmation of the first amended plan. The Deutsch declarations explain the debtors have satisfied the provisions of Section 1125 and 1126 of the Bankruptcy Code as applicable. The declaration shows that voting classes 3 and 4 unanimously voted to accept the plan. The debtors also filed a comprehensive memorandum of law in support of approval of the disclosure statement and confirmation of the plan. And while that memorandum is not evidence, it is part of the record before the court. The memorandum lays out with specificity how the debtors have satisfied the various statutory burdens and requirements. With respect to the disclosure statement, I'm satisfied the debtors have carried their burden under Section 1125 of the Bankruptcy Code. The disclosure statement contains, among other things, background regarding the debtors, events leading to Chapter 11 filing, the classification and treatment of claims and interest, a summary of the plan, including releases, injunction and exculpation provisions, risk factors to consider, and tax consequences. The disclosure statement contains information adequate to permit a hypothetical stakeholder to make an informed decision to vote for or against the plan, so I will approve the disclosure statement on a final basis. The requirements of Section 1129 are not at issue with respect to confirmation of the plan, so I will not address each standard governing confirmation, but I will note the following. The plan satisfies the best interest test, the Draglin Declaration and the liquidation analysis annexed to as Exhibit C to the disclosure statement reflect that the projected recovery for impaired classes are equal to or more than the recoveries estimated in a hypothetical Chapter 7 liquidation. The court finds, based on the financial projections attached as Exhibit D to the disclosure statement, as well as the Israel Declaration, that the plan is feasible and satisfies the requirements of 1129A11. Importantly, the plan deleverages the debtor's balance sheet by approximately $597 million, provides debtors with access to a new RCF, and leaves holders of general unsecured claims unimpaired. With respect to the opt-out, the SEC and the United States trustee have objected to the opt-out mechanism for third-party releases. As a threshold matter, I find that the third-party releases are consensual because holders had the ability to opt out of the release. The record reflects that the ballots, the notice of non-voting status, and the opt-out forms, and the combined hearing notice each quoted in its entirety the third-party release in bold, conspicuous font, informing holders of the steps to take if they had disagreed with or did not intend to grant the third-party release. With respect to the notice of non-voting status specifically, the text box on the first page of that notice states in bold, "This opt-out affects your legal rights. Please read this opt-out form carefully," and explained holders were releasing certain parties and how to opt out of the third-party release. Again, in a prominent text box at the end of the same notice, there was an additional reminder that parties consented to the relief if they did not opt out. The affected parties were on notice of the third-party release, including the option to opt out or to object to the third-party release. As such, the third-party release is consensual as to all creditors and interest holders who did not opt out or otherwise object to the plan. As I and others on this court have previously ruled, when the disclosure is prominent and conspicuous, an opt-out mechanism is a valid means of obtaining consent. It is incumbent on affected parties who have been properly served to protect their own rights. Parties that fail to act in response to a judicial process are routinely bound by the results of the process. The objections to the opt-out are overruled. The U.S. trustee also challenged service through nominees on the basis there's no assurance that the beneficial shareholder received the opt-out form or had time to complete the form. It is customary for public corporations to rely on the nominees to serve notices and other corporate communications. I see no reason why service of court-approved solicitation materials, including court-approved documents such as solicitation materials, should be treated differently from the service of proxy statements or other corporate documents. And let me be clear, if a holder was not served with notice, the release is not binding on them. Finally, the SEC argues the court lacks jurisdiction to approve releases with respect to the public shareholders, holders of convertible notes, and holders of subordinated claims who failed to opt out of the releases. The court disagrees. The court can exercise its authority because the consensual releases are integral to this restructuring as explained in the uncontroverted Israel Declaration. And lastly, based on the declaration and absent any objection, I find that cause exists to waive the stay of the confirmation order so that the order should be effective immediately upon its entry. So I will enter the order with a modification. And I'm looking at docket 268. I'm looking at the black line. And I just, and this may be something that I'm just not reading correctly. I'm looking at paragraph 30, which is on page 13.
And this is in the black line?
Yes, I believe so. Yes.
Okay.
3 lines up from the end of that paragraph, it's actually on page 14. And we are talking about all the documents and agreements necessary to implement the plan. It says they have been or will be negotiated in good faith and at arm's length. I have no doubt that the parties will negotiate in good faith and arm's length, but I cannot make that perspective finding. So I think that you could simply at the beginning of that sentence, which is the second line on page 13, I think you could just insert there, the debtors have represented.
Okay. Before the sentence that starts all documents?
I think that would cure the issue.
sense, and we're happy to submit a revised proposed order.
But otherwise, I have reviewed the order, I have reviewed the resolutions that are set forth in the order, and I have no further comments on the form of order.
Thank you, Your Honor. We will make that change and submit it very quickly.
Okay. Is there anything further for today?
Nothing from the debtors, Your Honor, but I believe counsel to the crossover group may want to.
Okay, and I have one comment before we close, but I'd like to hear from the crossover group.
Your Honor, Benjamin Deller from Sullivan and Cromwell on behalf of the crossover group. I rise only very, very briefly to say thank you to you and your chambers and to the parties. Debtors Council and Your Honor have summed it up very well from our perspective today, and we appreciate everything, all the help that Your Honor has given to this case. And we look forward to a prompt emergence now that we have confirmation behind us.
And did I read that's anticipate the 17th?
I believe the 16th or whichever.
Okay.
Late next week, whichever the Friday is, I believe is the target date.
That's great. Well, I wanted to congratulate the parties because, frankly, 2 weeks ago, the parties were headed to a contested and delayed confirmation process. And I appreciate that the parties, the amount of effort that was required to get to a confirmation hearing today. And although the confirmation was not consensual, the magnitude of your efforts were not lost on this court. So I congratulate the parties for being able to expeditiously come to a resolution with the creditors committee. Did anyone else wish to be heard?
No, I mean,
Sir.
Be very brief. Todd Myers, Kilpatrick Townsend for the official committee of unsecured creditors. Your Honor, while it seems like I've been in this case for 3 months, it's only been 3 weeks. And in that time, we dealt with the propriety of my client's existence and the propriety of the deadlines that were set for confirmation and how these cases would proceed. And while we were confident in our positions on those issues, we were less confident on what we would find if we were allowed to exist and given the time to evaluate the cases to determine whether the note holders were truly in the money. Obviously, the trade creditors were being paid 100 cents on the dollar, so it was hard to improve on that. In any event, the parties fortunately got together and we worked out a deal. The committee believed, all things considered, this was in the best interest of the committee. We were able to obtain some warrants for the unsecured note holders. We were able to make sure the indenture trustees fees would be paid so that they didn't have to use their charging lien from the value of the warrants. However one would go about doing that, I'm not sure. And we were able to make sure, also with the U.S. trustee who raised these issues, that the 100% for the trade was really 100 cents, that there was no, I don't think there was a intent, but we wanted to make sure there was no inadvertent language regarding injunctions which would not allow these creditors to pursue their rights outside of bankruptcy. We worked with the debtor and the lenders over the weekend and into this week regarding the plan. All of our comments were incorporated. We had a last-minute issue regarding the warrants. We were able to work those out. And so we are comfortable that this is in the best interest of all of the creditors, both the trade and the note holders. And with that, we're happy that Your Honor is confirming the plan. So thank you.
Thank you. Is there anyone else who wishes to be heard today? Okay, thank you all very much. Have a good day. We stand adjourned.